For pronouncement of judgment, item 20, WBC 305/2025.
Writ petition is dismissed.
Item 21, WBC 1837/2025.
Writ petition is dismissed.
Ma'am, item 7, there's an office note, my lord. That note is the order of the court to place my application for withdrawal of wakalat to the registry. That has come, my lord. I would like to withdraw my wakalat.
Okay, just wait for some time.
Not-
May I please, your lordship? My lord, I beg to mention for urgent listing of a matter at the motion tomorrow, my lord. My lord, the matter relates to police action, my lord. Oblige, my lord.
Wait, please, Lordship. Lordship, item number 6 may kindly be adjourned. The adjournment slip has been given.
Okay, 6, there is an adjournment
Yes.
note. Okay. Both sides are represented on this clear made by the conference petition. This is adjourned today. List after 2 weeks. Item 6.
Yes.
May it please Lordship, Lordship on WPC for listing.
Listing, it will be delayed because we are taking up those APSC matters. We won't have time to take up these matters.
Lordship,
What
it
is the
has been
urgency?
Listing 2 times, but been left.
What is the urgency?
Lordship, has been listing 2 times.
Listing is okay, but what is the urgency?
Lordship, long pending matter.
Just wait, we'll have to wait for 2 weeks more. You give it to them, they'll process it, but it'll be 2 weeks later. We are hearing a batch of matters, we can't hear another matter.
May I please have Lordship? Lordship, I beg to mention item number 9, Lordship.
9,
Yes,
okay, there's an adjournment slip. Okay. 9, 2 weeks.
Oblige, Lordship.
Lordship, I seek your lordship's indulgence to mention a matter, my lord, which is not on board today, my lord. The matter regarding that Nigerian national issue, my lord. I have received some instructions, my lord. Actually, it was sent to me on 9th when the matter was over.
The Nigerian national.
Yes, my lord.
Okay.
Well, lordship, may kind of peruse this instruction, my lord, para 2. Because instructions are already issued to the state government, my lord. They can take up the issue with the MEA. In 2014, itself, instructions were issued.
Okay, this matter is listed when?
On 30th, my lord. So it was supposed to be listed on 30th.
30.
30.
Okay. Please give a mention memo. We'll get it tomorrow, listed tomorrow. Give a mention memo. We are returning you this letter.
My lord.
But Mr. Adhikari, we appreciate you have done it very fast.
Item 1, Parthard matter for admission.
My lord, on the other day, I have submitted at length the relevant points involved in this case. Now only for your lordship's kind reminder. First thing, my lord, there is a school certificate. Headmaster was not examined, but lordship may award, that is one judgment, that school certificate may be even admitted without examining its examining its author. So I have given that is Shyam Lal, 2009, 12 SCC.
Shamlal, is that case was regarding dispute of paternity?
No, that is a different matter, but ratio, I am on ratio.
No, ratio must be read on the basis of facts of the case. Yes, this is a family matter. Here the ratio is that the child who was born, his parentage were disputed. And the Supreme Court held that during the relevant time, the mother had access to the father and therefore she could have been validly born. So that is the issue, because for that 112 is of the Evidence Act comes into play. It's not a determination under Section 50 of the Evidence Act, but determination under Section 112 of the Evidence Act.
I only limited priority this. As in the instant case, though that is was a family matter, but school certificate has been given some value.
No, that is true, because of the fact that the father got the name recorded of the son in the school, in the register, and therefore even in the absence of everything, it creates a relationship under Section 112.
Here is also the father, when she was admitted in the school, that is in the year, my lord, school certificate. In the year, that is page 37, my lord.
In
Yes,
the
37.
judgment you are citing, you see last paragraphs 33 and 34 of this Shamlal.
Yes, 33, my lord. Well,
We may also tell you that depending on Shamlal, cases were cited before us of acceptance of ratio of Shamlal for the purpose of acceptance of the proof of birth. Then, having known this, since I was aware of the facts of this judgment, I distinguished in one of the matters sitting with the sitting with honorable, another honorable judge, we distinguished that the Shamlal is based on different facts. And therefore the previous precedents we did not follow. Even our court accepted the Shamlal, and there are judgments accepting the testimony as proof of birth. But I have distinguished.
And then, my lord, here, when she got admitted in the school, her father recorded his name as she's the daughter of this
We'll take note of your submission.
Muhammad Ali.
We-
So, my lord, at that time there was no existence of this Foyders case. So, in that period, when she was the girl of about 5-6 years old, at that time she was admitted in
We have
this.
noted your submission. We are not rejecting your submission. Once you are setting this case, we are
And Lordship would kindly consider these types of cases are not, strict proof is not necessary. And they have not also challenged that this is not the true school certificate. So that may Lordship may kindly see, consider. Regarding other submissions, my lord, here is the evidence of Julha Sali.
school certificate is exhibit number
School certificate was not exhibited. That is, my lord. I'm
or not
sorry.
exhibited.
Not exhibited, but it was produced. So that was the deficiency of conducting the case. However, that certificate we have annexed. Lordships may kindly look into his judicial notice, my lord. And second thing is this, my lord, Julha Sali is the DW2. And he is the younger brother of the petitioner. And Julha Sali has adduced evidence and said that I am the son of Muhammad Ali and she is my sister, elder sister. Julha Sali's statement is page 29, madam. Julha Sali's statement, page 30 may be statement. 29 is the voter list of Julha Sali. Kindly see page 30. 29, operative portion, page 30. Julha Sali, Julha Sali, son of Muhammad Ali. This Muhammad Ali is his father as well as my father. This is the voter list of 2011, madam.
Voter list is page number
29. And the names appear in page 30. And another thing, my lord, it was not submitted before us.
just a moment.
ঠিক আছে, এটা দেওয়া ভালো। আছে। এখানে দেওয়া ভালো, এখানে দেওয়া ভালো হয়েছে। Yes, now Lordship kindly see page 21. This is the voter list of 1965
Yes.
in the name of Muhammad Ali. Serial number 118. And this Muhammad Ali's father's name is written as Golab Sarkar. The 65 voter list. Now, Muhammad Ali's name is there along with his father, that is my grandfather. And my grandmother's name is also there. My mother's name is also Sajitan Nessa, wife of Muhammad Ali. Now, Lordship would say that my father's name appears in the voter list of 1965. So it is no way can be disbelieved, my lord. And then Lordship would see page 23. This is the voter list of 1970. Here is also my father's name is there. Muhammad Ali, son of Golab. Sarkar is not here. So these are common, my lord. And here is also the name of my mother, Sajitan Nessa, wife of Muhammad Ali.
Yes.
Then page 30 I have shown already. Julhas Ali, who is my brother, his name is in the voter list of 2011. This Julhas Ali is son of Muhammad Ali. Now, this Julhas Ali's evidence, Lordship may kindly see. Page 52.
Yes. Yes.
I, Julhas Ali, age 46 years, son of late Muhammad Ali, resident of village Bhulukabari, so-and-so. I am the brother of second party, namely Sufia Khatun, of the above noted case. And I am a bona fide and genuine citizen of India. Then my sister was born and brought up at village Bhulukabari, Mauja, Bedbari, PS Borpeta, district Borpeta, Assam. So, my lord, this entire evidence, if your lordships kindly go through it, would see that his evidence and her evidence, Lordship, I am inviting your Lordship to page 46, her evidence.
Yes.
46. So she has also said that I am genuine Indian citizen, and para 2, I was born and brought up at village Bhulukabari, Mauza Bedbari, PS Barpata, district Barpata, Assam. So here, my lord, the evidence of this petitioner and her brother are totally telling with each other. There is no discrepancy. And my lord, so far the cross part is concerned, that is page 48. My page 48.
Yes.
My date of birth is 5/5/1960, and I have no birth certificate. I was born at Bhulukabari. The name of my father is late Muhammad Ali, and he has expired 3 years back at Bhulukabari. The name of my mother is late Sajitan Nesa, and she was expired about 4 years back at Bhulukabari. The name of my parents enlisted in the voter list of 1965, 1970. Then a little from below, 5 lines top from below. The Lordship would say, it is maintained by 2 brothers, namely Shamsul Ali and Julhas. So Julhas Ali's name has been stated by the petitioner proceeding. I have filed this register cell deed before this tribunal, and there is also registered deed matter, that is Exhibit B. If your Lordship kindly give me the LCR for a moment.
It may not help you. If we give you this,
Exhibit B, my lord, is there. That is the cell deed of the year 61, where my father's name is there with my grandfather. It is tallying with the voter list.
we are flagging and giving to you. There are 2 copies of the sale deed. And then you'll understand why it gave us a headache.
Here, my lord, this is Exhibit 2. Here, Muhammad Ali, son of Pita Gulab Uddin Sarkar.
We can't read.
And this is also Gulabuddin, Muhammad Ali, Pita Gulabuddin. Gulabuddin Sarkar is there. So who is my grandfather. So this are exhibited document, that is Exhibit B, my lord.
We have seen that.
Now, it is the deed of 4/1/66. And Lordship, now I am again inviting your Lordships to page 49, my lord. Page 49, bottom. My husband is a landholder and owner and purchased so-and-so land measuring 1 bighah situated at Kaljar. Name of our local Gaubura is Umar Gaubura, and I have filed the certificate as issued by the respective Gaubura. Now, this Gaubura has adduced his evidence that Lordship may kindly see page 59. 59, Rashapursi, Para 1. I am the village head or Gaubura of village Bhuluka, Bari, Mauza, Bedbari, PS Havli, district Borpata, Assam. The second party, namely Sufia Khatun, daughter of Muhammad Ali, is of village Bhuluka, Bari, Mauza, Bedbari, PS Borpata, Assam. He is known to me from her early stage. The second party, namely Sufia Khatun, daughter of Muhammad Ali, was born and brought up at village Bhulukabari, Mauza, Bedbari. 4. The second party's father's name is Muhammad Ali, son of Golab Sarkar. So it is clearly in the name appeared in serial number, voter list, etc. House number he has said. Now, serial number 5. That the second party father Muhammad Ali's name has been appeared in the register cell deed, Bhait land deed number 55 covered by pata number so and so, dated 4/1/66, which I have just shown my lord. The second party's father Muhammad Ali's name has appeared in the voter list of 1970, so annexed exhibit C. So, Lordship, he has given a very clear picture. He knows me from my childhood. And he is the local Gaura of my village. And he has clearly adduced evidence that I know her and her father. And my lord, so far the cross part is concerned, that may be seen page 63, my lord. 63. Cross part of Gaura.
Just one.
Yeah.
That's LCR.
Relation of the answer, non-local information. But don't non-process. Sorry. But you don't need the overnight. That I can use. But it is. দুটো কেউ দিয়ে দিবে। তিনটা আছে। তিনটা আছে। তিনটা করতেছে। দুটা বাজার ছিল, দুটা আর্জেন্ট ম্যাটার।
কি হয়েছে? No. अभी अपनी सही करना है। कोई करने को बुरा नहीं। वो चीज़ तो ही है।
Some extra is there. Read fiction. Or who will have to do. My lords, my concluding submission is this. If your lordships kindly go through the evidence of the three witnesses, that is myself and my brother and Gaura, there was also cross-examinations by the other side. So they could not find out any discrepancy, major discrepancy, or to some extent there may be some a little difference, but that will not affect my case. So, and I have also given the citations value with name of the parties. Even our High Court's various orders, including Supreme Court's orders. So I hope that the lordships will kindly go through these. And as the case under FT is preponderance and probability, the full-blown decision of the State versus Muslim Mondel's case, it is also said That's probability, preponderance and probability. Lordship would kindly consider all this aspect and would decide the case in my favor, setting aside the order of the learned tribunal. That is my humble submission, my lord. My lord, my junior would be here. I am going. My lord. Huh?
Yes.
We have- let me know.
Yes, Mr. Sharma.
Yes, Lordship.
Well, I am sorry, my lord. Another item. My lord, another item is there 10, my lord. In, if your lordship kindly be pleased for 2 weeks adjournment, item 10. Because similar matter sometimes we also perplexed our brain.
Okay.
Item 10.
Item 10.
10 after 2 weeks. Highly obliged.
My lord, my humble submission is that there is no infirmity in the opinion passed by the learned tribunal, Lordship, and Lordship procedure relied on school certificate, Lordship, at this test, Lordship, that may not be accepted at this test. Apart from that, Lordship, this school certificate has no date, Lordship, when it was issued, Lordship, and Lordship, at the top of top, Lordship, state emblem is embossed, Lordship. So, Lordship, this certificate may not be accepted as valid piece of evidence at this test, Lordship. And if this school certificate goes, Lordship, then there nothing will remain, Lordship, to prove her case that she is the daughter of late Muhammad Ali, whose name existed in the 1965 voter list, Lordship. And
Yes.
yes, then, Lordship, otherwise, Lordship, all the evidence are oral statements, Lordship. An oral statement is not enough to prove one's citizenship, Lordship. And Lordship, if we see the WS, Lordship, or evidence that are not adequate, Lordship, WS may go through the written statement, Lordship.
Yes.
And
Just the relevant part, we don't
yes,
have
Lordship.
to read the entire written statement.
Lordship, here in this case, why I'm saying, Lordship, written statement is not adequate, Lordship, because at this in this written statement, proceedee has concealed some vital statement regarding death of his father, Lordship, which is more important, Lordship, to prove her citizenship, Lordship. And Lordship, although one Julhas Ali has adduced evidence, Lordship, as a younger brother, Lordship, but Lordship, proceeding totally failed to establish that lordship, that Julhas Ali is the actual brother of the proceeding lordship. And lordship regarding lordship oral statement lordship, Bijoy Das case is very much clear lordship. In 2000 2018 3 GLT 118 lordship.
2018 3 GLT.
118.
Yes.
Yes, lordship. Para lordship. Seventeen lordship, it is tried that mere filing of written statement and oral testimony in a proceeding under the Foreigners Act 1946 would not be enough. The fact in issue would have to be proved by the proceeding by adducing documentary evidence which are admissible and relevant. The two documents filed by the petitioner were not proved in any manner whatsoever, and therefore the assertion of the petitioner that he being the son of Bipul Das, who was a citizen of India, was therefore a citizen of India was not proved, lordship. And lordship, so many decisions has been passed by this honorable court, lordship, and law has been already settled that lordship oral testimony in a proceeding under foreigners in a foreigners proceeding, lordship, is not enough, lordship. It has to be substantiated by documentary evidence, lordship. And lordship may, apart from that, lordship, tribunal's opinion is very much clear regarding that, lordship. Page 68, lordship. I am reading from bottom second paragraph, lordship. DW2, who claims to be younger brother of the OP, could not support her at all. He has stated that their mother died about 4 years back, but OP has stated that her mother expired about 7 years back. So contradictory statement has been made by both the proceeding and DW2. So, and lordship, DW2 also states that his father had a plot of land measuring 10/12 because covered by Doug number so and so. But interestingly, the total area of land is so and so, and was purchased by Muhammad Ali Mia as reflected in the schedule of the land. And lordship, regarding this land document, proceeding is totally silent, lordship, in her written statement, lordship. And lordship, another important aspect is that, lordship, there is also, lordship, there is a lack of continuity, lordship, in this case, lordship. From 1970 to 1989, lordship. There is
Just one.
Hello? Is it disputable?
Yes, Mr. Sharma.
Yes, Lordship. Lordship, I am just reading section 6A2, Lordship.
6A2.
Yes, Lordship, Citizenship Act 1955, Lordship. Page 7 of this book, Lordship.
Yes.
Yes, subject to the provisions of subsection 6 and 7, all persons of Indian origin who came before 1st day of January 1966 to Assam from the specified territory, including such of those whose names were included in the electoral rolls used for the purpose of the general election to the House of the People held in 1967 and who have been ordinarily resident in Assam since the dates of their entry into Assam shall be deemed to be citizens of India as from the 1st day of January 1966. So, Lordship, first he has to prove that he must be he has been ordinarily residing in Assam since the date of their entry, Lordship. So, Lordship, how they can prove they are ordinarily resident in Assam, Lordship? So, there must be continuity, Lordship. Otherwise, they cannot prove Lordship. And here in this case, Lordship, there is no continuity from 1970 to 1989, Lordship. They cannot prove their continuous stay in Assam since 1970 to 1989, Lordship. And apart from that, Lordship, a tribunal, in his opinion, Lordship, para 68, relying last para, Lordship.
Yes.
The Honorable Supreme Court in Life Insurance Corporation of India and another versus Rampal Singh Bissen reported in 2010 for SCC 491 specifically held that mere filing or exhibiting of a document in court does not amount to proof of its contents. Admission of a document in court may amount to admission of its contents, but not their truth. Document not having been produced and marked as required under evidence and cannot be relied upon by the court. So I am also relying this citation, Lordship, as supporting this statement of the tribunal, Lordship, and Lordship, Lordship, that's all, Lordship, my submission, Lordship. And there is a and um, that's all, Lordship. Gabura evidence to go to phone.
Newspapers here. We have newspapers here. I've taken it out. This insert it again. Just check it up, huh? You see, heard Mr. M.U. Mahmood, legal counsel for the petitioner. Also heard Mr. Mr. G. Sharma, and it's standing counsel for the FT matters. Mr. M. Islam, legal counsel appearing on behalf of Mr. A.I. Ali, standing counsel for ECI, and Mr. P. Sharma, additional senior government advocate. Next one up. As As it is projected that the petitioner has been taken into custody and is currently lodged in the transit camp, Matia Gwalpara. The matter has been heard out of turn at the admission stage. Most of the submissions of all sides are concluded. Judgment reserved.
My lord, may I submit one, lordship? Lordship, Gaubura's evidence, lordship, page 61, lordship.
61.
Yes, lordship.
Yes,
Verification part, lordship.
yes.
I, Umar Ali, aged about 62 years, son of late Ibrahim Ali, resident of village Jarabari, Muza, Bedbari, PS, so and so, do hereby solemnly affirm and declare that the statements made in above are true to the best of my knowledge and belief, and hence I put my hand in so and so. Lordship, March 20. So, Lordship, so what Gaubura has deposed before the tribunal, Lordship, that those all statements are based on personal knowledge of the Gaubura, Lordship. It is not from record, Lordship. So, statement made by Gaubra only on the basis of personal knowledge cannot be accepted as valid piece of evidence, lordship. Yes. Yes. So.
Okay.
Item 2 for admission.
Who is John? Watch. Yes.
Adjourn for the day.
Um, 2 weeks. Okay. Adjournment slip was given. We are adjourning it.
Because item 3 is a writ appeal by Numaligarh Refinery Limited against the impugned judgment, with which, my lords, on an application moved by the contractor, the learned single judge has been pleased to stay the invocation of bank guarantee.
No, 1 minute.
No.
My lord, before my learned friend begins, my lord.
Yes.
Before my learned friend begins, my lord, the writ petition is pending today. It is listed before court number 4 today. And my prayer would be, my lord, the matter has to go back to the arbitrator. Even this matter regarding the BG, I will pray that it should be within 30 days, arbitrator will decide. Because the matter, it has to be, my lord, it has not been ascertained how the claim will be made. It is not a case, my lord, or it is not a law that you will cancel the contract and soon thereafter you will encase the BG. There is no such law.
My lords,
So therefore, therefore, I will be praying before the learned single judge dispose of the matter, because the petitioner is proceeding with the arbitration or say seeking damages. So even in respect of this BG, my lord, I'll be praying that the BG matter should be also heard by the arbitrator for the 30 days, my lord, that status quo should be maintained. That will be my prayer.
lords,
Subject to that, my lord, my
There
lord.
are two difficulties with the suggestion, my lords, made by Learned Senior. Number one, my lords, till date, there is no arbitration proceedings.
No, will be proceedings.
No, my lords. This is, my lords, all my lords being said orally, but till date, there is no notice under section 21. The impugn order, my lords, unfortunately is not passed under section 9 of the Arbitration Act. We can understand because there is an arbitration clause. If I was about to invoke the bank guarantee, you might have gone to section 9 and sought rightly, because that only the petition which would have been maintainable. You did not invoke section 9. What you do, you move an interim application in a pending writ petition where there is no final relief with respect to bank guarantee. You simply move an IA saying that please stay the invocation of this bank guarantee, and this is the impugn order law. Now today, each and every day, my lords, of this, because I am a PSU and the project is a mega project, my lord. The amount of the bank guarantee is 3 crores odd. Each and every day, I am suffering a loss due to deprivation of this amount, my lord, which is I am rightly entitled to. So today for them, it is very easy to say, let the status quo continue for another 30 days. My lord, I have already suffered for 2 months deprivation of this bank guarantee. Kindly see what are the findings in the impugn judgment. No finding of fraud, no finding of irretrievable injustice, my lord. Loss. Bank guarantee, my lord, law is very clear. Lordships are, let's already, I cannot show lamp to the sun, but let's, the law, as I may reiterate, is that you cannot stay a bank guarantee unless there is a grave case of fraud, which is not there, Lord. Please have the impugn judgment.
But if the matter is listed today,
Lord.
this what you call this?
Writ petition.
No, this order is valid till the next date of listing.
But what happened when the impugn judgment was passed? The observation in the impugn judgment last para is, if I may just invite your lordship.
It says two things. Number one,
Yes.
fix the matter on the for final disposal accordingly. Direct the parties to maintain status quo till date,
Yes.
and then with the observation, it's disposed of. So
Yes,
it can
that's a-
still be taken up today.
But let's know the problem is in the writ petition. Well, that's the problem. The paradox which they have created for themselves is they file a writ petition in January, my lord, on 7th of January to be precise. If we see the reliefs of the writ petition, there is no relief regarding bank guarantee. What they say that the termination of the contract done by me is illegal and should be declared as illegal asset. No relief with respect to the bank guarantee, my lord. Now, bank guarantee, as the lordships have said, stands on a different footing than termination of a contract. Here, the bank guarantee was invocable by me for any default. It not necessarily, well, it's necessarily be termination. So termination is an issue different. Now the bank was not a party to the writ petition because there was no final relief with respect to the bank guarantee. What they do after 2 months of filing of the writ petition, when I had already invoked the bank guarantee, they moved this interim application saying that I have invoked the bank guarantee. Therefore, please stay the invocation of the bank guarantee.
No.
I had already invoked. The problem was, my lord, the bank guarantees was invoked on 2nd of January 2025. I prepared a short list of dates, 1 pager, my lord. Just be with me for this, my lords, because today it is me who is suffering despite all the law being in my favor. I invoked the bank guarantee on 2nd January 2025. They file a writ petition on 7th of January 2025 without any iota of whisper regarding this bank guarantee. So the writ petition, the subject matter is not, my lords, related at all to this bank guarantee. The bank sits upon the bank guarantee, Bank of India, my lord, the respondent number 2 in this writ appeal. He does not encash for reasons best known to them. Rather, the bank writes to the contractor immediately, my lords. This is beyond any, my lords, legal permission. Bank cannot write to the contractor Bank writes to the contractor, invites their comments. Contractor says, please don't encash the bank guarantee. And this goes on for 2 months till the time the contractor, well, it's my landed friend's client, move this IA in this writ petition. And then the impugned judgment is passed. So today, my lords, the problem is this. My lords, the law is well settled that any interim relief in a writ petition can only be a relief which has a nexus with the final relief, or which is an aid to the final relief sought in the writ petition. Now, my lords, in this case, the bank guarantee is not even an issue in the writ petition. The bank is not even a party to the writ petition. He was impleaded only for the purpose of this IA. So today, if the writ petition is disposed of whichever way, my lord, the problem will be, as an interim order, it will get merged with the final relief, which will be a dichotomy in law. So this writ appeal is to be decided before the disposal of the writ petition, my lord. Otherwise, the doctrine of merger will hit me bad. Number one. Number two, please see the impugned judgment for a moment. If it is sustainable in law, my lords, I appreciate.
Page.
Just starts at page 18, Lord. And the page 20 rather. Page 21 to 21C is the, my lord. Now, please have, may I invite your lordships? I'm sorry.
You see, in the writ petition, what was the next date fixed?
It's fixed today, man.
With the impugned judgment, it was fixed for first week of April 2000.
Did it reach on that
It did not
time?
reach.
It was
Did
it was listed after that. It is listed today.
It was listed in the meanwhile also, Lord. The matter could not be taken up. That was 5th of May. And now it is listed today. My lords, my submission
Which page is that order you were referring to?
my lord, impugned judgment says at the bottom, that is page 21D.
Page 21D.
21D, para 16. Having considered the submissions of learned
Just a
counsel for the
moment, just a
parties
moment.
and considering,
Just a moment.
I'm so sorry.
You see, that is why we are amused. We were just discussing.
Please.
The interim order is to the effect that till final disposal, parties would maintain status quo. Correct?
Yes.
Because in the operative part of paragraph 16, it says that the directing the parties to maintain status quo till writ petition is disposed of. That is one. But second part says that the interim order would be that status quo would be maintained till the next date.
That's
You say that after first week of April it was listed,
on 5th of May.
5th of May. If the interim order was not extended, why this appeal? There's no interim order at all. You are now inviting an interim order at yourself.
No, I bow down with the observations made by lordships. But for me, my lords, if the impugned order says status quo till pendency of the writ petition,
No,
that is also hitting, my lords. That
No.
is third line.
you see, but after that, what does the court ultimately give you? It says
that's-
status quo as, till the next date.
That is correct, no? That is correct. So if my
Status
lords,
quo till next date is not extended.
my lords, I bow down, my lords, because if something is written in this order, and my
No,
lords,
you will
if-
be, you see, we only decide, you interpret. That is your job. Now, do you say that, are you inviting on yourself a proposition which is not there in the order? Do you say that the interim order is still operating against you? Can you make that submission?
my lords, at the best, I'll say if there is an ambiguity, one recourse was me to seek a clarification. but then also I might have invited trouble for myself.
But it's not
So-
there. There's no interim order. That's why we are amused.
My lords, I'm happy that way also. If there is no interim order, my lords, today in my favor, lords, find this writ of privilege is, my lords, not required. No problem. But today, my lords, please see the larger picture. Being a PSU and being within the entire realm of the law and a contractual thing, bank guarantee is a contract, unconditional bank guarantee. Why I cannot invoke it? And when I've invoked it, then the application, the only relief wherein
There's a academic question. We won't answer that. If there's no interim order, there's no interim order. What is the cause of action to come in appeal?
absolutely.
Mr. Das,
May it's up to him, my lord, bank is not a party here.
No, we have
in
impleted.
this IA is a party.
No,
No, I think. there
bank is
a-
respondent number 2 in the appeal. They appeared on the last date of hearing. They sought time to file reply,
It's Up
etc.
to them, my lord. So far, single judge has passed an order. Extension was not there because of probably on the date.
It's not there. It's not
It's
there.
up to them.
No, bank was impleted as respondent number 8 in the IA. And then
See,
this
whatever,
direction.
whatever happens has happened.
My lords,
On merit,
may I,
if your
may I
lordship
lodge-
is not discussing merit, my lord, let it
Because
fall,
if
my lord.
we don't say anything, because if the interim order is, it has lapsed, we don't say
Yes,
anything,
yes.
one line order.
my lord, if it
Yes.
is left, please mitigate, my lords, my situation. I'll only request that, your lordships.
We won't say
Well,
anything.
Normally, your lordship knows that bank guarantee, my lord, we either go to the arbitrator, but in.
We are not obliged to say anything.
Of
Once
course,
it is,
of course.
it is there, it's there.
my lords, but the problem is that line which says that should be maintained till disposal of the writ petition.
Please read that again.
Yes.
I have read it. That's why we said that we were amused.
Having considered the submissions of the learned counsel of the parties and considering the termination of the contract has been put to challenge in the writ petition, which is pending for disposal, I am of the view that interest of justice would be served if this IA is disposed of by directing the parties to maintain a status quo till the writ petition is disposed of, as it would appear that so and so, so and so. Then, and then the last line it says, accordingly, it is decided, directed that parties to maintain a status quo till the next day.
So this is the direction. Others are obiter. I may, in a given case, I may say that the accused deserved to be hanged to death. And then I say he is acquitted. What would you read in the order?
And then you have to give it to the court.
You just close it. We make an observation and close it.
Lords.
So that's, you were saying something.
It's all right. Since your lordship has decided, I don't want to put words. I'll be doing it before court 1 today itself. Court 4.
Yes. If then.
These are judgments, my
Apprentice-
lord, which says, my lord, unless it is adjudicated, BG cannot be invoked. Either I have to go to the arbitrator or to read petition, we can file, my lord, because of the exceptional circumstances.
It's okay, but
That's
we
correct.
leave it to you. You
Yes,
can agitate the matter there.
Well, it's only
And the
one,
matter is pending today. It is listed today itself.
only one caveat, my lord. In the last date of hearing, and your lordships, I'm very much thankful to your lordships to make this observation. On the last date of hearing, to my fortune, unless there is no extension of this interim order.
We not, that's why we told you, that's why you started just saying that we
Yes,
were
yes.
amused.
Yes,
You are Mr. A. Garg,
yes, ma'am.
heard Mr. A. Garg, learned counsel for the appellant. Also heard Mr. B. Das, learned senior counsel, assisted by Mr.
J. Lotha.
J. Lotha, learned counsel for the respondent number 1.
Actually, my lord, sum and substance of the order is till disposal of the High Court. But if your lordship is deciding otherwise, my lord, I am submitting, my lord.
No, because the
I'll
word
be-
used is direction.
No, that's
Direction
ultimately-
contains,
Ultimately, since matter is now listed before the court,
yes, yes.
court
we'll-
four, in that view of the
we'll
matter,
close
what
it
should
right
your
now.
lordship decide, my lord?
We'll close it right now and we'll try to upload it.
Yes,
Uh,
because my
but
lord, matter is pending before the court, writ petition is pending, whole matter will be decided.
No, this matter is
Today
no more
itself.
pending before the writ court. That's
Well,
my grievance, my lord.
No, this IA is
Even
closed.
writ
It's
petition-
closed.
Writ
Your
petition is
lordship
open.
record my submission that today I'll be submitting for referring the
No,
matter.
that's
to the-
okay. We don't want to
Yes,
put this, but the problem is that IA is disposed of.
Yes,
IA is disposed of. Acha, there's a office
actually,
note.
they should have filed
Can-
an application there itself.
Can any of you tell us, there's a office note here that the cost title has not been amended.
We have amended and filed the amended because now only respondent number 1 and 2 are the parties here. Respondent number 1 is the contractor, respondent number 2 is the bank.
Only two of them are there.
Only 2 of them.
Okay. Let me say, none appears call for respondent number 2. By filing this intra-court appeal, the appellant has received the order dated 5/3/2025 passed by the learned single judge in WPC 142 of 2025. Next, the operative part of the order, which has been assailed in this intra-court appeal, is extracted below. Paragraph 16, page 21, D. I put a flag. Next paragraph. Next paragraph. From the above quoted paragraph 16 of the impugn order, notwithstanding that the observation of the court was to dispose of the interlocutory application by directing the parties to maintain status quo till the writ petition is disposed of. But at the later part of the order, the direction is to the parties to maintain status quo till the next date. Next paragraph. The learned counsel for the appellant has submitted at the bar that the writ petition was listed last on 5/5/2025, correct?
Yes.
Next paragraph. Be that as it may, though the direction was to maintain status quo till the next date, but the interlocutory application has been disposed of. The next paragraph, thus, from the submissions made at the bar, it appears that the order of status quo has not been extended by any subsequent order passed in the writ petition. Next para, accordingly, comma, the court is of the considered opinion that there is no live issue involved in the present intra-court appeal. As the status quo, which was to be maintained till next date, has not been extended thereafter. Next para, at this stage, the learned senior counsel for the respondent number 1 has submitted that the matter is listed, the writ petition is listed before the learned single judge today.
This may not be required now because
No, it's okay, it's listed today. We take note of that. Next, accordingly, having not found any live issue in this intra-court appeal, this appeal stands closed.
please,
Learned single judge will not be influenced by any
Okay.
observation.
that issue is not there before the learned
No,
single.
it's okay.
Because
Nothing
ultimately-
contained in this order shall prejudice the parties when the writ petition is heard on merit.
Very well. Lords, can I just seek, Lords? Bank should now honor the bank guarantee.
We can't, we won't say anything.
Otherwise, my lord, otherwise, my lords, the bank will continue the way it has continued to, my lords, dishonor the bank guarantee.
That gives you right to, what you call, blacklist the bank.
My lords,
Don't
we
accept
are
their
taking
bank
it-
guarantee.
Against the bank, we have a separate remedy. But the money which has to come to us, my lord,
No, but we are not exercising original jurisdiction.
My lord,
We
will
won't say
be
any word.
definitely will be taking the matter if the arbitration notice. will be
Whatever you
put-
say, but you see, Mr. Gar, we are not exercising original jurisdiction. And
That's
therefore, we will
correct.
not make any observation. You,
Lords, my submission is, request is only this.
no, we.
Had your lordships, my lords, there are,
We'll, you see,
please,
that will cause you, it's your choice. Because if you make a submission, then I'll have to record it and answer it.
I'll not, my lords, go that far. But the only anxiety is, my lord, today,
No, we understand, but we have our limitations.
I appreciate.
If
I
you,
think-
if
and
you
do you
pose a
oblige-
question, then we'll have to respond to
Do you-
it.
The learned single judge will decide independently.
You said
That's
not to
the-
be influenced.
That is the
by
problem.
anything
without
coming
influence,
in.
well.
This should not carry a message for the learned single judge that the bank guarantee issue can again be, my lord,
No, you see.
The entire matter. will
You,
be-
I'll just for in a lighter note, we tell you. What meaning something somebody will understand out of the order. We have to leave it to their wisdom. Because you made this challenge, you have made a 500-page,
this was
Uh,
filed before the.
no, whatever happened, but you have filed a 500-page memo of appeal and we found not a live issue. So it
became bulky.
depends. That
When
is
I-
why we always remember Mr. Ashok Sen. Yesterday, somebody told it was Mr. Nariman, I don't know, but I've heard it about Mr. Ashok Sen. He said, Mr. Mishra is there, he will know. I was just reminding myself of the observation of Mr. Ashok Sen, earlier law minister. He had once given a statement that if I am paid, I will also argue before a lamppost.
Yes.
It was him. Correct. So what somebody would understand of it, we leave it to Almighty.
Very well.
Oblige.
We'll take a short break. Having seen Mr. Mishra, we empower ourselves and come back.
Well, it's 29 of the supplementary, that APSC matter.
We are taking it up at 2 o'clock.
Well, this, well, I'm told Mr. Diganto Das was arguing, he has not completed his argument
Yes,
and he'll complete it next week.
yes.
Well, I'm making a request that I will argue after him.
Okay, you'll follow him.
I will
You're
follow-
you're not like that.
Because last time what happened,
But you're not like that.
my lord, last time what happened? Something I can't, my lord, tell in the open court. Last time, what happened before the then Chief Justice Sandeep Mehta and the judge? I completed the argument. After that, Mr. Diganto Das came. And then it was sent to.
No, because we
Supreme
have some limitations this time.
Yes.
We propose to complete it within this 7-8 days.
The day he completes, next day I'll argue. I'll
No, but somebody else will have to argue because we are not adjourning it
maybe
in the
that-
series, huh? Because unless we conclude it, there is every likelihood that if within 7-8 days we can't complete the hearing, we'll have to release it.
That's one thing, and because there are so many left, still left.
No, we understand, but that is a limitation.
That 30-day limitation your lordship is talking about.
Uh, just at 1 o'clock when you rise, you can come into the chamber, we'll tell you.
I have to go, I have to go somewhere. And, as your lordship says that,
We have certain limitations because you see, there are different, I'm associated with 2 different other benches.
I
And
know, I
there are matters which are parted.
Yes.
And that is creating a lot of headache. Once it is a parted matter, it's creating a lot of
But
headache.
this one, I can tell your lordships that this will not be get over in 7 days, because after that, they make submissions, we'll have to make reply.
No, we understand. But
Therefore, so far as I'm concerned, then if your lordship, I can start, but I will take some time. And then I can start on 2 o'clock on Tuesday. Because Mr. Digonto is coming on, and is coming on Wednesday perhaps. So I will start, but then only after I complete, then he should get, he can resume his argument.
no, definitely.
So
Because
Tuesday,
what we are proposing is that if the arguments are lengthy, then perhaps you can argue on the bullet points and give us a written note, because that will be helpful, because
I can,
because we really can't, there
I
are
can-
limitations, we can't extend the hearing for more than 7-8 days.
I can-
Then we'll have to,
I think I'll try to do that.
yeah.
Can be done. So then 2 o'clock Tuesday, I'll make my submissions.
But we'll pass orders when the matter comes. Mr. Prasad, please be here. At 2 o'clock, we'll pass orders.
Daily list item 4 for admission.
Maybe Lordship. Lordship, this is the petition challenging the ex parte order, Lordship. The ex parte order is at page 61, Lordship. I have been declared as a foreigner, Lordship. I have not appeared before the tribunal, Lordship. Because, Lordship, I have explained in para 9 of this petition, Lordship, why I have not appeared, Lordship. I was misled by one Farooq Khan, Lordship. He told me that, Farooq Khan told me that come to me and give me 250, 2,500 and the case will be finished. Later on, Lordship, he handed a few days after, Lordship, he handed over one voter ID card, fake voter ID card. And thereafter, the petitioner believed that his case had been literally finished. Thereafter, he did not appear, Lordship. Later on, he came to know about the order, Lordship, when the police came to arrest him. And while he was in the state of UP, Lordship, and he came to the house and applied for the certificate copy, and then he moved before this honorable court, Lordship. I have every document, Lordship. My father's name appeared in the voter list of 1965, 1970, 1985, 1989, 1997, Lordship. I have land document, Lordship, whereas I have inherited land from my father, Lordship.
Are you sure before moving this writ petition, you have read the writ petition?
Yes, Lordship.
Have you read the writ petition uh, before you are making submissions today? Have you read your writ petition?
Yes, Lordship.
You have read. Very good. Now, if you have read it, then please read it with me. Come to paragraph 9. Please read paragraph 9. Few lines only.
That the petitioner begs to state that he is a drunken person and also suffering from.
He is a drunken person. So male.
Yes, Lordship.
And suffering from mental disorder.
Some
Correct.
thoughts of Lordship. Because he drunken person, so he moves here
Yeah,
and
that's
there
okay.
sometimes.
But what is the name of the person who has filed the FIR at page 63? Uday Banu, wife of,
Lordship, his cousin sister, Lordship.
huh?
Cousin sister of the petitioner, Lordship.
Cousin sister.
Because he fears that if he go there, then he will be arrested.
And where is the receipt of the OC or the some person from the Thana receiving it? Where is that?
Lordship, they have not provided any receipt, Lordship. But if he has submitted the Lordship, this,
Oh, that is. When you are free, you go to your go to our registry and you will find many things are being filed there. Every matter filed there is not listed.
Lordship, in the FNL bottom Lordship 2519 bracket 9, that is the NTA Lordship, that serial number of that day Lordship they have filed Lordship. Anyway, Lordship, I was misleaded Lordship, that is why I could not appear Lordship. I maybe give one chance Lordship, I will appear before the Lordship. Daily basis, I will not miss any date Lordship. That observation may be made Lordship. With any conditional Lordship, I may give a chance Lordship.
Yes, Mr.
Lordship.
Sharma.
Lordship, otherwise, Lordship, there is no infirmity, Lordship, in the opinion. And tribunal rightly passed the opinion, Lordship. And Lordship, these are only statement, Lordship, para 9, Lordship. And Lordship, that person, Farooq Khan, was not made party here, Lordship. Although
No,
one lost an affair.
If he's a party and he's supposing he comes in here and says that yes, I did that, would that be an evidence?
But Lordship, in this FIR was registered or not, that was not mentioned, Lordship. Lordship, is just case number is not here, Lordship. Page 64, Lordship. Registration. FIR for? Huh? Huh? এটা কি GDM 2 হ্যাঁ কোড কোড এটা GDM 2 নম্বর কি দিছে হ্যাঁ Immediately after filing of this FIR, Lordship.
Just a moment.
Yes, Lord.
In this writ petition, have you produced any voter list?
Yes, Lordship.
Which one?
Lordship, there is no voter list of in the name of precipitation, Lordship, because he have been put to D, Lordship, since 1997, Lordship, for the first time. Though his name was recorded, but D was there, Lordship. And in the certificate should be D, those person who have D before them, Lordship, their name could not keep blank, Lordship. Land document is there, Lordship, which establishes a linkage with his father, Lordship. Page 38, Lordship, vernacular.
You were saying something?
Lordship, immediately after filing of the FIR, Lordship, this petition has been filed, Lordship. And Lordship, otherwise, Lordship, I think, Lordship, there is no infirmity in the opinion, Lordship. And Lordship, another aspect is there, Lordship, petitioner,
The Learned Council is only wanting one chance to appear before the tribunal and contest the case.
Lordship, then Lordship, some cost may be imposed, then Lordship allow him to go and contest the case, Lordship. Otherwise. Lordship, this reference was initiated in the year of 1998, Lordship. No. Already, Lordship, more than 25 years has been done, Lordship. And if your Lordship willing to remand the matter, then some time limit also may be fixed, Lordship, within short span. His father is also existing since 1997, Lordship, from different village, Lordship, and at the age of 47 years, Lordship, page 27. Hmm? Bonbahar. Oh, yes. Oh, village is village is same, Lordship, but his name appeared at the age of 47 years, Lordship.
Doesn't match. We'll tell you why. Come to page 38. Serial number 26 is Sri Rahman Khan. Correct?
Yes.
He is the petitioner.
Yes, Lordship.
Page 38, serial number 26 is the petitioner.
Yes, Lord.
Correct. Now come to page 41. Second entry, চক্ৰবিষয়াৰ ইমান তাৰিখৰ হুকুম মতে উত্তৰাধিকাৰী দখলকাৰী সূত্ৰে এই পাট্টাদাৰৰ 309 আৰু 310 দাগৰ 13 নং পাট্টাদাৰ চান্দ খানৰ স্থলত 25 নম্বৰ ৰহমান খান you are 26 27 নম্বৰ ফৰমান খান পিতা চান্দ খানৰ নামত নামজাৰি কৰা হ'ল নেক্সট চিঠাত চক্ৰবিষয়াৰ 29/3/2012 তাৰিখৰ হুকুম মতে হৰিদা সূত্ৰে পাট্টাদাৰ চয়নচৰ লগত 13 নং পাট্টাদাৰৰ ৱাৰিছ 26 নং চয়নচৰ নামটো আহিল that means you have purchased it your name doesn't appear as uttaraধিকাৰী of your father.
No, Lordship. I have inherited from my father, Lordship. There may be.
We don't know. We are just. I am reading it. You have shown it to us, and we are reading it.
Lordship, Farman Khan is my brother, Lordship, and Quddus Khan Manna.
We don't know. Your name is 26. We confirmed that you say that your number is serial number 26. 26 doesn't get land by way of inheritance.
Yes, by way.
By way of purchase.
Lordship may be there, Lordship. This may be.
No, we don't know. What may be there, may not be there, we don't know. What we see is what you are reading.
Lordship, that is there, Lordship.
So how you are establishing yourself to be your father's son? You don't get inheritance. 25 and 27 get inheritance. You are out. You purchase. It's not your case that you have purchased inheritance.
Printing mistake may be there, Lordship. It is maybe printing mistake, Lordship. Lordship, if you see, Lordship, the 20 serial number 25.
No, you see, we can't say it is a printing mistake. Government.
Lordship, maybe there may be.
No, we don't know. Maybe or may not be, we don't know. But you are producing a document. You can't say that I am producing a document knowing that it is got printing mistake.
Lordship, it is not I have not written this document, Lordship.
We understand. We are not accusing you. Have we said that we are accusing you of tampering with the document? We are not saying so. You have annexed it. We are just reading it.
Lordship, in the voter list, Lordship, Farman Khan is there, Lordship. Farman Khan is my brother, Lordship. And my name is not there, but in the extract copy, Lordship, my name is there, Lordship, with my brother, Lordship. But in the certificate copy, my name is not there. That column has been left blank, Lordship.
Okay.
I need to give one chance, Lordship, only, Lordship.
You are Mr. R. Islam?
Yes, Lordship.
We'll consider, we'll deliberate in the chambers.
My submission, only submission in is Lordship. I may
Just
give
a
one
moment.
chance.
Just a moment. We are remanding the matter to the tribunal for a fresh decision. The in the other opinion of his mother, there are some documents which are matching.
No.
If the mother was a Indian in 1970, although the presentation is not up to the mark, but it's an opinion.
Lordship, this land document is a post 71 document, Lordship. Land document page 36.
No, but the mother and father's name match in the earlier opinion. We were checking all the documents of the previous opinion of the mother.
Lord.
There's some match.
Some cost may be imposed. As there is no infirmity in the opinion, Lordship.
Heard Mr. R. Islam, the counsel for the petitioner. Respondents are there. Mr. M. The speaker one. The ex parte opinion dated 17/1/2023, passed by the learned member of Foreigners Tribunal First, Borpeta, in so page 61 is said in this writ petition filed under Article 226 of the Constitution of India. The petitioner projects that on receipt of the notice of the tribunal, he had gone to a person who assured to the petitioner to fix the matter. And despite service of notice, the petitioner did not appear before the learned tribunal. Under such circumstances, the court finds that the petitioner is a willful defaulter in appearing before the learned tribunal. If the petitioner goes to a person who is not a advocate, on receipt of a summons of the tribunal, the petitioner has done so at his own risk. Therefore, on the said ground, court is disinclined to interfere with the ex parte opinion dated 17/1/2023. Next paragraph. Nonetheless, on a perusal of the materials appended to the writ petition, it is noticed that the petitioner is relying on opinion dated 21/9/2011, passed by the learned member, Foreigners Tribunal First Borpeta, in page 32, in so and so, in respect of proceeding named Kasiran, Kachiran, Kasiran Nessa, who is the projected mother of the petitioner. First off, by the said opinion dated 21/9/2011, the mother of the petitioner was declared to be not a foreigner. In the said opinion, the projected mother of the petitioner placed reliance on a voter list of 1989, which purportedly contains the name of her husband, who is projected to be father of the present petitioner. Under such circumstances, notwithstanding the serious objection made by the learned standing counsel for the FT matters against interference with the impugned opinion, the court is of the considered opinion that one opportunity be granted to the petitioner to prove his citizenship. Next paragraph. It is made clear that the court has not expressed any opinion as to the documents produced by the petitioner in this present writ petition. So therefore, on demand, it would be open to the learned tribunal to examine the veracity and correctness of the documents on which reliance is placed by the petitioner, and examine the materials produced in accordance with law. Next paragraph. On account of the fact that the petitioner is a willful defaulter in appearance before the learned tribunal, despite receipt of notice, as a precondition for remand, the petitioner is directed to deposit a cost of rupees 1 10,000 before the Guwahati High Court Legal Aid Committee, which shall be done within a period of 7 days from the date of the order. And acknowledgement of receipt of the same shall be produced before the learned member, Foreigners Tribunal, First, Borpeta. Next para. Subject to deposit of cost as a precondition. Comma, the court is inclined to set aside the impugn opinion dated 17/1/2023, passed by the learned member, Foreign Tribunal, First, page 61. Next, the petitioner is directed to appear before the said learned tribunal within on or before 6/6/2025, and by producing a certified copy of this order, as well as a copy of tendering of cost to the Guwahati High Court Legal Aid Committee. Comma, shall also produce his written statement of defense and submit all the documents along with the written statement. And thereafter the learned tribunal shall pass necessary orders to fix the matter for evidence. Next para. As the reference against the petition is of the year 1998, comma, it would be permissible for the said learned tribunal to hear the matter as expeditiously as possible, comma, if required, by giving short adjournments. By fixing by restricting adjournments and by fixing short dates. Next para. It is also made clear that the petitioner does not appear before the learned tribunal within the time allowed. It will be permissible for the said learned tribunal to pass a fresh ex parte opinion, treating the petitioner to be absent on call. It appeared within 6/6 without notice. Next para. The registry shall demand back the records of FT case number 881 of 2018, as well as FT case numbers 79 of 2010, back to the said learned tribunal.
Lordship, may I submit one thing, Lordship? He cannot submit 10,000 Lordship. He's a poor person, Lordship. May it reduce to 5,000 Lordship.
No, we can't. You see, you went to a third party.
Lordship.
They gave you a, you see, we have a reasons. That's why we are saying. You see, first of all, you say that you went through a third party. Then you say you got a epic at your name. You also say that there was a D-voter in tag, and despite that you got a epic. The epic, you don't produce it here.
Lordship, I have
It would be
the police station, Lordship.
no, before this court, it will be suppression of material facts. If there are suppression of material facts, you take your own risk.
Lordship, 5,000 Lordship.
No, we are not negotiating that.
Others case also nothing, Lordship, except the suo motu affidavit is.
It's a 98 opinion. You have successfully thwarted all actions till 2025. It's 27 years now.
Lordship, this is the case of the reference was the 1998.
We don't know about that.
But
You are
it's-
paying the cost. We are
yes,
not
yes.
negotiating on the cost. Cost you'll have to deposit.
That's very difficult, Lordship. if possible, Lordship.
You see, please don't make us say something which nobody will like. You have sufficient money to be a drunkard. It is your own statement in paragraph 9 that I am a drunkard. Therefore, for that you have sufficient money. You don't need to borrow money for drinking.
Lordship, thinking in village area, Lordship.
I don't know. It's I have been told by some people that it is prohibited. It's, I don't know. So to do something which is prohibited, you have sufficient money. So don't make us say things. Oh, there's a meeting. Yes. Yes, we have all the other matters will be adjourned because we are taking up APSC matters.
My misfortune, today I got a chance to appear before Lordship, my lord. Some matters, criminal matters, my lord, it came several times before Lordship, my lord.
We will take it up.
Several times, my lord, it came.
15,
this-
16, 17 in our list.
No, because there will be disruption for at least 10 days. Since we are taking up those APSC matters. There will be disruption of 10 days.
So far our cases, so IA may be considered, my lord, the next, as your Lordship. Next Tuesday, my lord, only for IA, not just the main, my lord,
No, Tuesday again matters are fixed. Let the court master take a call.
my lord.
Fix it
Next
on the
week,
day.
my lord.
My lord, one item, my item, today is fixed. She's in jail.
We can't help it.
My lord, today it was fixed, my lord.
Huh?
That matter, my lord, detention camp. Petition detention camp, item.
Detention campus, short date. Oh, Mr. Ahmed.
So my, it will come for orders, my lord, but that's why I'm appearing, my lord.
Okay, let the court master take a call.
That bench of my lord, that item number 15,
No, there is continuously two bench,
That's
which
my-
will be,
I
so that's
appreciate
why
that.
the difficulty.
but.
The court master will take a call. He'll give a date.
So it will come for orders, what I am interested in. Once it come here, normally it does not.
No, you make a request, we can upgrade it
My lord,
if required. If you want an AI to be considered, just tell the APP and then
my lord, I told her.
My matter will be taken up tomorrow, my lord.
we'll do it tomorrow.
Well, I am appearing for item number 53, my lord. My lord, in this matter, my lord, I am appearing for Dr. Ganesh Chandra Das, who is my lord, accused number 58, my lord. Another is Deepshikha Pukan, my lord, accused number 52, and Monica Terangpi, accused number 48, my lord.
Okay,
These three accused persons.
just a moment.
Yes, my lord.
One is Ganesh Chandra Das.
Dr. Ganesh Chandra Das, accused number 58.
Yes.
Srimati Deepshikha Pukan, accused number 52.
Just. Deepshikha Fukan, she is accused number
52.
52. Third is
Third is Srimati Monica Terangpi, accused number 48.
yes.
Yes, my lord. Here,
Item
my lord.
53.
Yes, my lord. File to decide, no?
It will come.
Yes, my lord.
Hmm.
Well, in the instant case, my lord, what happened, my lord? We were, my lord, first, my lord, arrested in connection with, my lord, in a case, my lord. And subsequently, we were suspended from our service, my lord, under Rule 6, my lord. And some disciplinary and appeal rule, my lord. And thereafter, what happened, my lord? After, my lord, 4 months of suspension, my lord, I was, my lord, discharged from my service under Rule 20C of Assam Disciplinary and Appeal Rule. First, your lordship kindly come to our appointment letter, my lord. That is dated 13/9/2026, my lord, page 76.
Appointment letter dated.
Dated, my lord, 39/2016, my lord.
Yes.
In
Page
the-
78.
Page 76, my lord.
36. Yes.
One name has been mentioned, my lord. As per recommendation of Assam Public Service Commission, Guwahati 781003, so and so, the following Assam Civil Service with effect from the joint Assam Administrative Staff College, so and so, Guwahati on 18/10/2016. All the person who has been appointed, my lord, as an Assam Civil Service officer, my lord, ACS officer, my lord. In that, my lord, name of the Monica Terongpi found in serial number 17, my lord. Who is accused number 3, my lord. Petitioner number 3 in the instant case.
Yes.
Then next page, page 77, my lord. Serial number 24, top of the list, my lord. Sri Ganesh Chandra Das, petitioner number 1.
Yes.
And another 33, my lord, serial number, Sri Deepsika Phukon, petitioner number 2, my lord.
Yes.
Date of, my lord, appointment letter was issued on 39/2016, my lord. And, my lord, thereafter, we join in our service, my lord. And, my lord, as per, my lord, you will say Annexa 3, page 18, my lord. We are, my lord, a completed joint induction training course, my lord, page 80, Annexa 3.
Just a moment. You are showing us which page?
Page 76, your lordship.
76 we
Yes,
have
my lord.
seen. After
And
76,
thereafter, page 80.
18. 80.
80. I want to show, my lord, we have successfully completed all the departmental examination. That is why I am shown one by one, my lord.
Yes.
Page Annexa 3, page 80, my lord. My lord, original is next page 81, my lord. This is the type copy, my lord. Serial number 70, Monica Terangpi, Assam Civil Service Provisioner, Ganesh Das 24 and Deepsika 33. I read that part, my lord. The following probationer, release order thereafter date 28/9/2017. The following probationer, Assam Civil Service batch, who have successfully undergone 2-week joint induction training course for probationer for ACS and allied service with effect from 18 to 28 October 2016. 4 weeks foundation training for Assam Civil Service 1 to 20 are hereby released to enable them to join their respective place of posting. After successfully completed the training period, we are released from that, my lord, Assam Administrative Staff College, my lord, and thereafter we join our respective post, my lord.
Yes.
Next, Annexure 4, page 84, my lord. that is 1/12/2016, my lord. Page 84, Annexure 4. On completion of training in the interest of public service, the following Assam Civil Service Junior Grade year 2016 batch probationer are posted as Assistant Commissioner in the District Subdivisional Headquarters mentioned. Here, my lord, petitioner number 3 was appointed, serial number 17, as Assistant Commissioner Kokrajhar, Monica Terangpi, serial number 17, my lord.
Yes.
Next, Ganesh Chandra Das, Assistant Commissioner Nazira, serial number 24, and Dipsika Bukon, 33, Assistant Commissioner Margherita, my lord.
Just a moment.
Yes,
Just a moment.
yes.
Having been disposed of the next date. Obviously, the next date, when the petition is listed. Yes, 84, 85.
Yes,
You've
my
seen
lord.
those entries?
Yes, my lord. And I want to show something, my lord. There are 87 persons name were mentioned, my lord, who were appointed, my lord, in 2014 batch, my lord. If your lordship go to page 87, my lord.
Yes, 87 people.
87, page 87, last page, my lord.
87.
Serial number 87, my lord. Reason why, my lord, there are, my lord, you have to pass, my lord, 2 examination. One is, my lord, survey settlement training period, and another is, my lord, language. Out of, my lord, 87%, my lord, only 45% has completed these things, my lord. Other could not pass in there. My humble submission before your lordship is that I want to show, my lord, due to my inefficient, I was not terminated from my service, my lord. That is, my lord, important reason, my lord, behind it, my lord.
Yes.
Page 88, my lord, that 18 August 2017, my lord, has said the following SES officers are deputed to undergo survey and settlement training 3.5 months commencing from 1/9/2017 to 15/12/2017 at the Assam Survey and Settlement Training, Rajaghar, Dakshin Gaon. They are directed report so and so. During the period of training, they will stay so and so, my lord. Name has been mentioned, my lord. 20, same, my lord. 26, Monica Terangpi. 33, Ganesh Chandra Das. 42, my name has been mentioned. Sorry, my Dipsika Bukon name has been mentioned, my lord. Annexure 6 series, page 92, my lord, your lordship. That is important, my lord. The governor of Assam is pleased to declare the following 31012 to 2017 at Assam Survey and Training, Dakshin Gaon, as proficient in the subject shown again is in order of merit. That we have completed proficient, my lord. That meaning we have successfully completed the training, my lord. The Ganesh Chandra, the same serial number 13, Dipsika 24, and Monica 31, my lord. Proficiency, done proficiency in subject survey, PS, and land record and settlement, PLR. Serial number 13, Ganesh Das, 24, Dipsika Pukon, and 31, Monica Terang Pimal. This was on 13/2/2018.
Subjects of survey land.
Nothing to you.
My lord? Yes,
This smile is not directed against you.
yes, my lord. Actually, my submission before your lordship is that whether, my lord, my discharge from my service, whether it is a, my lord, termination simpliciter, or there is a, my lord, foundation on the basis of police leader, where stigmatic view has been taken. This is the main crux of the issue. But I want to show, my lord, as if they are, my lord, discharge me, that I am not, my lord, efficient to, my lord, discharge the duty. That is not there, my lord. Whether there are some other officers, my lord. There, my lord. I am coming, my lord. Thereafter, my lord, one other one. Page 94, my lord, same type, my lord. Monica Terang be subsequently cleared, my lord, land record and settlement training, my lord. Both meaning thereby my all three client has completed, my lord, survey, PS, and land record training, my lord. Similarly, my lord, we have there is a one language paper is there, my lord. Your lordship knows that language paper also we cleared, my lord. That I am not reading, my lord. Name has been mentioned, my lord. I can show your lordship also.
So we take your word for it.
Yes,
This
my
is
lord.
only we don't dispute.
Yes,
We're
my
not questioning your
Yes, my lord.
statement.
Sorry, my lord. 170. Her name is Mr. Monica Terangpi.
No, we'll take your word for
yes,
it.
Yes,
We're
yes, my lord. Now, my lord, in the meantime, my lord, an FIR was filed on 27/10/2016, my lord, one against one Nobokanta Patir, my lord. That he has tried to give bribe rupees 10 lakhs to, my lord.
27.
This FIR was 27/10/2016, my lord. He tried to give bribe, my lord, No, sorry, my lord. Anshumita Gogoi has said Navakanta Patil has demanded money 10 lakhs from my lord for appointing him as a dental minor in a dental my lord, surgeon post, my lord. This, my lord, my humble submission before us is that Navakanta Patil was suspended and subsequently, my lord, I think he was reinstated, my lord. Subject to correction, my lord, Navakanta Patil, my lord. And my lord, in this case, my lord, in FIR, my name was not mentioned in the FIR, my lord. That is important thing, my lord. Because, my lord, FIR, nothing has been stated against me, my lord. All three accused person. I want to submit, my lord, because if I am, my lord, going one-to-one, my lord, this interesting part on my own, I have appeared before the, my lord, learned special judge, my lord. 161 statement, my name is not mentioned, my lord. Not a single 161. And they are said, my lord, at the midst of argument, my lord, in our cases, my lord, or because my seniors are good in this case, my lord. I was assist. My lord, at that time, my lord, midst of the submission, we submit that there is nothing in 161 statement, nothing. Because they are not producing anything. Then they file an affidavit, my lord. And affidavit has, they said that there is a, my lord, statement given, we 3% given, my lord, confessional statement before the police that we are giving, my lord, money to the Rakesh Pal, my lord. Important thing, my lord. We appear, my lord, your lordship knows very well. Nowadays, my lord, 207, all the document has been given after the Honorable Justice Ranjan Gogoi judgment, my lord, Sasikala Natarajan, which has been, my lord, relied by the prosecution or not relied by the
It was
prosecution.
V. Shashikala.
V. Sasikala, my lord. V. Sasikala, my lord. Relied or not relied. Every document has been given. We could not find, my lord, this document, my lord, confessional statement there. That is important because everything should be in the CD, my lord. Then they said in official note, they have found these things, my lord. If it is not available in the case diary, original case diary produced before the, my lord, London special judge, how can it be found, my lord, in the office note, my lord? That is the crux of the issue, my lord. FIR, my name is not mentioned, my lord. And this FIR was filed after, my lord, hearing is going on. At the time of, my lord, midst of the hearing, this
Office note to hearing on this.
in the office note, that hearing, that, my lord, has been produced. And it is not available in the special court, my lord. My humble submission that there is every doubt from my part that may be a fabricated document, my lord. And we could take this in the writ appeal also, my lord. This point we have taken in the writ appeal also, my lord. Because this is not available in the that, my lord. Special court, my lord. And whole, my lord, case has been based on the basis of, my lord, if this document go, my lord, only on two documents, my lord. One is the search sheet, my lord, and another is the FSL report, my lord. My humble submission before your lordship is that, my lord, search sheet is nothing but an opinion of the investigating officer. A search cannot be framed, my lord. There is the ample of judgment. Search cannot be framed, my lord, on the basis of, my lord, search sheet, my lord. There must be 161 statement. Even, my lord, this FSL report is a suggestive, my lord, evidence before the court, my lord. It is not the main evidence. I want to submit things because, my lord, your lordship is not very good. There are 32, as per question document, my lord, there are 32 characteristics of the handwriting. 16 should be, minimum 16 should be identical. Otherwise not. If, my lord, tomorrow, if we can say, I know, my lord, but if I say something, it will hamper the criminal case, my lord. That is most important, my lord. If tomorrow, my lord, said this report cannot be considered, my lord, then what is the position? Because there is no ocular evidence against the accused persons, my lord. Sorry, my lord, against the petitioner number 1, 2, 3. So, my humble submission before your lordship is that if they are solely based on the police report, which is not conclusive one, my lord, Can, my lord, a person can be discharged, my lord, without giving an opportunity of hearing, my lord? Because Manoka Gandhi and others case also said, my lord, in their passport case, my lord, I am not here. And other cases, you have to give opportunity of hearing, my lord, to that person, my lord. We are not even allowed to submit any, my lord, written, my lord, a reply to that effect, my lord. And in respect of my efficiency, I have already submit, my lord. That is, my lord, my submission before your lordship, my lord. Now I coming to the, my lord, allegation in the, my lord, charge sheet, my lord. Yes, my lord. If your lordship go to this state allegation of this charge sheet, my lord, it was started from page 158, my lord. I am stating, my lord, what is available. In this allegation of the statement, nowhere it is stated that there is a statement against me, my lord, that we have, my lord, given bribe to the Rakesh Palmer, Chairman Rakesh Palmer, my lord, which has been, my lord, relied in paragraph 45, no? 43, 44, 45.
Of the single judge order.
A single judge, my lord. But that was not mentioned in the charge sheet also. যাইছো লাহে লাহে যাইছো মই এনেই ফাষ্ট আৰু তই আৰু নকৰিম বহুত শ্ল' কৰিছে I am not going to each and 158 page, 16.3 is the Monica Tarangpi, my lord. Everything has been mentioned against the Monica Tarangpi. And so far, Dipsika, page 162, my lord, 16.7. 158, 16.3 is the Monica Tarangpi.
Yeah, just a moment.
So 169 or a sentence.
One 150 is 8 is Monica Terangpi.
Monica Tarangpi.
Next.
Next, my lord, page 162, my lord, 16.7. Below part, my lord. Bottom, my lord. Dipsika Pukot.
Page number? Page number?
52.
Kindly give the page.
62. Page number.
162.
Yes, my lord. Below part, my lord, 16.7. Oh, 4 years.
Yes.
And another is, my lord,
169.
169, my lord, page
1.
16.13, my lord.
Yes.
And if your lordship goes, my lord, nothing but so and so in 161 statement stated against you, these things, that is not available. And if your lordship go to the 161 statement, my lord, nothing is available. That is on the, in the reflected on the record, judgment also, my lord. I shall come on later on, my lord. Then, my lord, your lordship kindly come to the, my lord. First, my lord, Rule 6.2, because I was arrested, my lord. That is why I was suspended from my service, my lord. Page 206. I may read, my lord. Whereas Sri Ganesh Chandra Das, DR 2016, Circle Officer 2016, Sonare arrested by Dibrugarh Police case on 18/7/2018 in connection with Dibrugarh PS so-and-so prevention করে, and he detained under custody beyond 48 hours. The governor of Assam therefore pleased to withdraw the service of Revenue and DM Department in exercise of power conferred under Sub-Rule 2, Rule 6, Assam Service Discipline and Appeal Rule 1960. Also, P. Ganesh Chandra Das is deemed to have been placed under suspension with immediate effect of his arrest until further order. Thereafter, my lord, all three were arrested. Then, my lord, bail order to listen, my lord.
11/10/2000, 187.
Yes, sir. I want to submit one thing, my lord, because I am going one by one, my lord. Lordship, kindly come to the page 216, my lord. There are, my lord, two persons, my lord. One is Abhilasha Borua, Abhisika Borua, and another is Sanjan Fukan, 216 page, my lord. What happened, my lord? They are become, my lord, approver. When they become approver, my lord, it is known to all, my lord, criminal case, they can get relief, my lord. They are not convicted, my lord. In criminal case, they will acquitted from the case. But there is no law under, my lord, service rule, my lord, that if a person has become, my lord, accomplice, my lord, then immediately, my lord, he shall also get benefit in the service matter, my lord. These two person was, my lord, not, my lord, terminated. Only they were suspended, my lord, and departmental proceeding has been started, my lord. And, my lord, they are, my lord, on the basis of, my lord, police report, on the basis of police report, they were suspended, my lord, and departmental proceeding were started. I am not in negative equality, my lord. And Article 14 and 16 said, and this is the correct procedure, my lord. As per my humble submission, my lord, this is the correct procedure that has been followed to the, my lord, Abhisika Borua and Sanjan Phukar. If they follow for one set of person which is correct, my lord, then same procedure should be followed to me also, my lord. That is my humble submission, my lord. Lordship, kindly come to the page 216.
We are there.
Yes, my lord. Peruse the report submitted by Superintendent of Police. Have you, Lordship, got it? Dibrugarh Police, Fight dated in connection with Dibrugarh PS case number 93616. It is reported that Abhisheka Bora circular has become approval in the Dibrugarh PS case and statement has been recorded 160 on CRPC. In which I made disclosure of inculpatory and exculpatory act. That is, level lordship got it. And the prima facie show her involvement in criminal conspiracy. We are also, my lord, conspirator. He is also conspirator. Only punishment, but he got the relief as because sorry, my lord, she was approval. Can I place, my lord? This is my lord, submission, my lord. Yes, my lord. If for that person, then thereafter, the Governor Assembly withdraw the service of Abhisheka Bora, Disaster and Management Department pending innocent departmental proceeding, her suspension under Sub Rule 1, C and Rule 6, Assam Service Disciplinary Appeal with immediate effect. We are on same footing, my lord. So far, my lord, service is concerned, my lord. So, and now, as per my lord, in instruction, this suspension order were, my lord, extended, no? Extended time to time, my lord. That has been annexed, my lord. I will come later, my lord. Then, my lord, we are all, my lord, subsequently released on bail, my lord. And, my lord, under 20C, my lord, we are termination letter. Lordship, kindly come to the page 209, my lord. I am reading one termination letter, my lord, because other are identical. 209, Annexure 14.
Yes.
209. In exercise of power conferred by Rule 20C, Assam Service Rule is pleased to discharge Srimati Ganesh Chandra Das, Probationer, ACS, Assistant Nazira, transferred to Sonori Circle Officer from service with immediate effect. All order is identical. Rule 20.6. If I was, my lord, discharged to Rule 20A and B, then that is different aspect of the matter, my lord. I was discharged on Rule 20C, my lord. And what is Rule C? If any information received relating to his integrity, age, health, character, antecedent, the governor is satisfied that provisional is ineligible, otherwise unfit to member of service. Moment integrity has come, my lord. Oh, sorry, my lord.
No, it's okay.
No.
Please continue. We are following you.
Yes, ma'am. Rule 20, ma'am.
Yes.
I am reading, my lord. Rule 20. A member shall be liable to be discharged from service if he failed to make sufficient use of opportunity given during the training, otherwise failed to give satisfaction during the end of period of probation. I could not come this, my lord. That is why I am reading. I have cleared every examination, my lord. If he failed to departmental exam, unless the governor permit him sit for re-exam, we all three passed the examination. We are, my lord, discharged in C. If any information received relating to his integrity, in integrity we come, my lord. Yes, health, career, the governor is satisfied the probation is ineligible, otherwise unfit being a member of service. If moment they have used, my lord, 20C, my humble submission before your lordship is there, I should get an opportunity to give my reply, my lord, to that effect, my lord. Whether this police report, what I am arguing before the court, my lord, I have to give to the, my lord, appointing authority that this police report, nothing is available, 161 statement or other, my lord. Only there is in the charge sheet, some paragraph has been mentioned, my lord. All these things, my lord, I can produce before the, my lord, appointing authority, but that chance was not given, my lord. So, my lord, there are many judgment, my lord, in the apex court, my lord. You have to give the opportunity of hearing, my lord. I will come later on, my lord, one by one, my lord.
And some order that are 238 of us.
Jaya, sir. I want to show one thing, my lord. 238 of the Senate.
230.
Your lordship, kindly look to the 238. That Obhisika Borua, his, my lord, suspension was extended time to time, my lord. Page 238, my lord. One order is 1st August 2019. Last part, my lord.
Special orders.
Before that, I am reading another line, my lord. That is also important, my lord, because we are on same footing. Where considering the seriousness of the case and the officer has already given her confessional statement regarding procurement of job by unfair means, it has been decided by the appointing authority that reinstatement at this service may not be interest of public service. Now, Governor is pleased to extend the period of suspension in respect of Visika Borua for another 3 months, 22/7/2019, till further, until further order, whichever is earlier. My humble submission before your lordship is there. Assuming but not admitting the allegation is correct, then this allegation is identical allegation, my lord. So far relating to Visika Borua and my client is concerned, and Sanjan Fugan also, my lord. So if you give opportunity to give, my lord, they are suspended, my lord, and departmental proceeding has been started to them, my lord, then why not, my lord, same benefit given? Because violates Article 14 and 16 of the Constitution of India. Well, I shall produce the judgment later on, my lord. Now I want to go to the judgment. No, এখানে আর get horse away. Here affidavit can have, no?
240 पर आरंभ हो मत किया इस 240 तेरा 30 दाग दिया सर
No. এই উত্তর তো বই পড়ে তো ডাক দেখে তো ডাক দিতে বলি না my lord, I want to, my lord, show the affidavit filed on 25/7/2019, my lord. 240 affidavit has been filed. Relevant page I want to submit, my lord, page 246, para 17.
Affidavit in the read proceedings.
yes
Read proceeding by. Irritable, in irritable, no affidavit has been filed. We are not getting that.
No, it's okay.
Yes, ma'am, we are not getting it. What am I to see?
ना हम काउंट किया
No, since the records are voluminous, we did not check it. That's why we are asking you.
I am asking him, my lord. Because something submitting before the court, we should be cautious, my lord.
No, you are absolutely right.
Yes, my lord.
That's how we were trained.
Para 17, my lord, page 246. May I read, my lord? With a view to restore public faith, confidence in public officers, as we ensure that the role of all persons involved in colossal fraud, that is important, is unearthed and ascertained, a detailed thorough investigation is being carried out by the police in the state, Assam, as submitted herein below. Report 170 CRP has been filed. The petitioner present batch of petition are accused of the trial 109, 120B, 201, 240, 460, 12, 13 to of prevention. The investigation certain aspect is still continuing, may require reserve of further supplementary report. I am here, my lord. Only thing is that, my lord, if they taken a view that we are involved in fraud, my lord, and other thing, my lord, and it was came out on the investigation, my lord, I should get an opportunity for hearing, my lord. In their affidavit, they have admitted, my lord. That is better. Then, my lord, page 254, para 34. Here they have said, my lord, the member, have you also got it? Para 34, page 230, 254. 254, my lord. Para 30. Para 34, the member of Assam Civil Service, such as petitioner in the presence, are governed by the provision of Assam Civil Service Rule 1998 and Assam Service Disciplinary and Appeal Rule 1964. They said the rule 1964, even we are professionals, it was applied, my lord.
Rule 9 to benefit.
And then, my lord, if they said, my lord, rule 9 of that Assam 64 rule, my lord, benefit should be given to us, my lord. Then, oh, like yes, like yes.
Improvement has been done, the money probably they were best to let you.
Anything has been done. তো বেলেগ affidavit খন দেখাব লগা নাই আমাৰ।
Comprehensive form to amount specifically দিছে।
আমাৰ specifically ৰেকৰ্ড আৰু নাই কেনেকা।
এইখিনি কথাই জানো।
Yes, my lord. Lordship kindly come to the, my lord, page 257, my lord. My lord, page 42. Hey, read below down to Lutheran. Moja Lutheran. Page 42, my lord.
Paragraph 42.
Sorry, my lord, para 42, my lord. Page 257. During the investigation, the writ petitioner have themselves stated to have paid money in lakhs for securing the appointment in question in following manner. P1 stated paid 25 lakh, P2 stated have paid 30 lakhs, P3 stated paid 40 lakhs. This statement, my lord, we are not getting till today, my lord. Witness examination?
27.
27 witnesses has been examined. Charge sheet has been filed, my lord. We are not getting this statement, my lord, anywhere, my lord, in special court, my lord.
207.
With 207 copy has been completed, my lord. Serving copy has been printed. So we are not found this copy, my lord. Because, my lord, when charge sheet has been filed, my lord, your lordships know very well, the case diary original has been produced before the my lord, concerned court, my lord. And nowadays everything has been given, my lord. But, my lord, no copy has been served to us, my lord. So, and as per my lord, actually no record to as per verification, we could not find these things, my lord. Actually no. Then next paragraph. During the investigation, one of the accused beneficiaries have also made a statement before the learned competent court, stating that number of candidates who stood appointment pursuant to the recruitment process initiated in the year 2013 and 14 have paid by securing the appointment to the public office. The statement of the said beneficiary have been submitted before this honorable court in seal cover for kind consideration. My humble submission before your lordship is that, my lord, at that time, investigation was not completed, my lord. That is why it was under seal cover, my lord. They said. But when the trial has been started, 27 witnesses has been examined, my lord, and no copy were found in the record, my lord, then how can they say it, my lord? So our submission before your lordship, this may be a, my lord, fabricated document, because this, and as per my lord, instruction of our client, my lord, no confessional statement has been recorded by the police, my lord. Itu lah diberi capability আমি point করছি না now I want to show the judgment তো তুমি
It will go.
Lordship, kindly take second volume, my lord. The Lordship, kindly come to the page 654, second volume. The judgment by the Honorable Single Judge, my lord. Page 654. Okay, number available. 43%. No, yeah, that's the
738.
মিলে একটা সাবমিশন তো আছে
19 নম্বর প্যারা।
তো লয় মোর দেশে এটা কি টাইম আছে 711
এই আছে রত্নেশ চৌধুরী জাজমেন্টটো নোট লৈছে কিন্তু কৈছে আমি পাছত এটা সাইটেশন পাইলো।
হ্যাঁ
এই যে যোনটো ৰত্নেশ চৌধুৰী ইলিগেল
বুজিলো
সাবমিশনটো লিখিছে কিন্তু পাছত কৈছে কি আমি এইটো লাইনত একো জাজমেন্ট দিব।
সেইটো I want to come, my lord, page 711, my lord. One judgment will, my lord, rely in the, my lord, before the Honorable Single Judge, my lord, Rotnesh Kumar Chaudhary. I want to show, my lord, in the submission, it was written down, my lord, on my note, my lord, the Bhuyan submission, although we also, my lord, submitted, para 11. AKB adopt the argument of so and so on fact, the petitioner must be deemed to be confined in the service. It is submitted that discharge order expressive punitive, the opportunity of hearing is mandatory. Relying on the case of Rotnesh Kumar submission made, it will amount to a stigma if the observer of language which impute or something over and mere unsuitability of the job. According to Mr. Bhuya, stigma it large impugn reliance is placed 1994 TSC Kata Singh, and to say the confessional made the police officer accused in the custody or before the accused is not probable against in a proceeding which is charge of commission of it. I am on Rotnesh Kumar Chaudhary, my lord. Your lordship, in Rotnesh Kumar Chaudhary, my lord, I will produce later on, my lord, has categorically stated, my lord, that there is no judgment to distinguish pre-appointment and post-appointment. I have gone to this judgment, my lord. Only one judgment I found this Rotnesh Kumar Chaudhary, no? Where pre-appointment, if there is anything, my lord, fraud or mistake has been committed, my lord, fraud, not mistake, sorry, my lord, fraud has been committed, my lord, irregularity has committed, then he is entitled for the, my lord, departmental proceeding. So far I go, my lord, so far I verified the judgment, my lord. I am come later on, my lord, the judgment part. Then you will also directly come to the main part, my lord.
738.
738, my lord.
Para 43.
Para 43, my lord. Para 43, have you also got it? 738 is.
Yes.
applying the above principle to the present cases to ascertain circumstances, foundational facts leading to discharge from the service during probation period, the original office file containing the note of arrest and suspension of the petitioner as well note of decision making process involving in consultation and approval accorded high government authority are perused. I already submitted, my lord, there is no, my lord, confessional statement, my lord. And another assuming but not admitting, my lord. If there, my lord, this is the foundation for discharging me from my service, my lord, then this is a stigmatic view they have taken, my lord. If they have taken the stigmatic view that I have given money, other things, my lord, then I am entitled for this entitled for submitting the, my lord, reply, my lord. That was not given in the instant case. I argued both way, my lord. One is that is not available, my lord. And another thing is that if it is available, my lord, what my land, sorry, my lord, what honorable judge has said, my lord, then, my lord, this is a, my lord, stigmatic view, my lord. If that is stigmatic view, I am entitled for the, my lord, giving opportunity to reply, my lord. Then again, next page, my lord, 739, all the name has been mentioned, my lord. After the name of Jyotirmoy Adhikari, have you also got it?
Yes.
The ground of arrest and material collected against the petitioner contained in the aforesaid office file. Broadly, investigation revealed that the petitioner involved securing job by adopting unlawful means. I am harping on that word, my lord. In collusion with the arrested accused person, Rakesh Pal and chairman and other arrested person. This is also, my lord, stigmatic view against me, my lord. Connected. During the course of investigation, written answer script, APSC combined exams was seized. So and so as Rakesh Pal. That handwriting sample of the arrested accused person as well as the petitioner were obtained, sent to forensic science laboratory for examination. It is revealed that answer script were not printed in government press. All the stigmatic view. I should give an opportunity of reply, my lord. In office file, my lord, in respect of, my lord, my suitability and performance, nothing is available, my lord. As per, my lord, as per paragraph 44, my lord. 43, my lord. Then, my lord, all the stigmatic view has been taken, my lord. During the course of written answer script, so and so, arrested, it revealed that answer script were not permitted in the government base. Also, the signature of invigilator of the answer script were found to be fake and mismatched with the invigilator who were on duty the respective day of examination in a particular examination. The fake answer script were written again by the witness after completion of the examination. Same were placed with the original and in connivance with Rakesh Pal and arrested. All are, my lord, stigmatic view has been taken, my lord. And all these thing has been done behind the back of the petitioner, my lord. Suppose, my lord, if this fact, my lord, stigmatic view has been taken, my lord, I should at least get the opportunity to give them, my lord, reply, my lord, that this thing not correct, my lord. Then paragraph 44. Without entering into any legal argument, as it admissibility, which is for the appropriate fora, the office file contains statement made by a section of the petitioner before the police, admitting to their complicity in the illegal activity to which they were beneficiary. That is not available in the special judge, my lord, file, my lord. That, my lord, criminal trial, my lord. That is not available because no copy has been served to us, my lord, to that effect, my lord. Because now trial has been 27 witnesses has been examined, my lord. The statement of such petitioner found in the file are that next page, Monica Terangpi, A48, Deepsika Fukan, A50 foot, Ganesh Chandra Das, A58. we categorically submitting before your lordship is that we are not given any confessional statement. And second thing, that is not available in the special just court, my lord, which is original record nowadays, my lord. Then how can a office file note, my lord, this statement has come, my lord? The next, my lord, name has been mentioned, my lord. Our name mentioned. The statement are basically with regard to the appearance in the APSC main exam, making payment of money 25 to 40 lakh Rakesh Pal through his agent for getting selection, APSC and securing job. All stigmatic view, my lord. Next page, para 46, my lord. I also rely on 45, my lord. The office file as indicated chronology record that in the event of taking following information received from Dibrugarh police at the arrest of petitioner in connection Dibrugarh PS 9/36/2016. From that, my lord, this knowledge has been gathered, my lord, all the document where I was arrested. From the decision calling from the detailed report from the Dibrugarh police for taking further action or receiving such report in connection arrest petitioner to the decision to withdraw the service of the petitioner pending action taken by personnel department, government of Assam to obtaining view judicial department for taking final decision. To obtaining approval, chief minister together with a view, the advocate general, so. Now, para 46. Clearly, the allegation irregularity on the part of the not allegation of any irregular negligence and efficiency misconduct taking place during the discharge of their duty or post-recruitment or having been appointed public office. There is so far pre-recruitment post. There is no judgment has been given, my lord, in respect of pre-recruitment. This process will be followed. Post-recruitment, rather, Ratnesh Chaudhary said, even it is pre-recruitment, you have to give opportunity, man. The allegation against the petitioner in indulging in gross irregularity, fraud involving payment, illegal gratification for securing appointment to the public are apparently pre-recruitment period, and that is before we are appointed public office. In the understanding of this court, element misconduct, which requirement and submission made on behalf of the petitioner is active in respect of period, valid initial appointment. Not a single citation can be proposal that irregularity committed during the recruitment process or before appointment had been made. We have given the judgment of Ratnesh Kumar Chaudhary. I will distinguish later on, my lord. Indeed, para 47. And it was mentioned in the judgment, AKBS submission, para 11 para that has been mentioned, my lord. Ratnesh Kumar Chaudhary has been produced. Para 47, my lord. Indeed, there has been...
Just a moment.
Can I continue tomorrow, my lord?
Just a moment.
Yes, sir.
We'll give you an opportunity.
Yes, sir. Because judgment, I have to go, my lord.
Because we are also in a hurry.
Yes, yes.
Because since we are taking up other matters and other bench also. So unless we hear it in one go, we tend to forget.
Yes, sir. I have pledged, my lord. I shall.
Just a moment.
এইখিনি অলপ জাজমেণ্ট এইখিনি কৰিলে তাৰ জাজমেণ্ট অকণমান চাবা আছিল
Oh, what we intend to say is that the it appears that the major part of your argument is over.
Yes, my lord.
What you need is to supplement it by some case laws.
Yes, law, my lord.
We'll suggest that you can give the case laws in a note and give the paragraph numbers.
Shall give the note and paragraph number, my lord, and as well as, my lord, I shall submit a written at the conclusion of the hearing, my lord, I shall submit a written argument, my lord, also, because
No, you
other
can
side
give
was,
you can give that in advance so that we can process it.
but my lord, what my learned senior friend will be submitted on the respondent side, my lord. I have to
Acha.
give answer all these things, my lord.
Okay.
So that now,
Because only in respect of whatever opening arguments you have made, even if you can give the written note of that.
that part,
you can- ha.
what I am arguing, that part,
Ha, ha.
with a, my lord, I shall submit again, my lord, what?
Definitely,
my
definitely,
lord.
definitely. That will not. We are not foreclosing that,
Yes, my lord.
so that we can process in the meantime.
Yes, my lord.
The
Yes, my lord.
Ju-
Your lordship is correct. As is ekhine
just a moment, because 50 appeal,
Yes, my lord.
50 reply,
Yes, my lord.
50 arguments in reply.
Yes, my lord.
Correct, and we have not more than 7 to 10 days
Yes,
to
ma'am.
complete that.
Yes, my lord. And sorry.
Just a moment.
Sorry.
We are looking at something.
Application to define now. Application to define now. সেইটো দেখা গ'ল।
Satisfaction the government, the policy of national natural justice or representative the exceptions at the point. So that should have been reflected in the discharge order. It will follow to stigmatic, it will be urgency, not promptitude.
Yes, sir.
A need for promptitude and the urgency of the situation, and whether has the effect of paralyzing the administrative system. So that it will be
এটা কি করবি? প্যারাগ্রাফ পঢ়িব লাগিব। 47 পঢ়িব লাগিব। ফাউণ্ডেশ্যন কৰিছে 48 পঢ়িব লাগিব। 49 ইয়াতে দিছো। মহেন্দ্ৰ সিং দিনটো হৈ যায়।
That I'm not stand next to the 26 to certificate the public say the program is what we will to the other way.
Where's that out?
Or is that there is some
সব ইয়ারের মধ্যে গিয়ে সব ইয়ারের মধ্যে হলে এগুলোকে নোটিস stated and explain in the given. This one I know, sir. দিলে ভালো লাগে তাহলে লাগে না দিতে লাগে না ফুলি না হলে ফুলিলে স্যার বোঝা না জানো
I want to show my something, my lord. Lordship, para 47, my lord. Page 741. Yes. Have you also got it? Yes. That's one. Indeed, there can be no hiding from the fact the arrest and material collected against the petitioner following FIR dated 27/10/2016, registered as Dibrugarh PSN, had set the ball rolling. The investigation report of Dibrugarh police were the foundational fact, and the gravity of which was considered by the government of Assam in the personnel aid department, which was eventually resulted the impugned order being passed. Proceeded by the consultation with the concerned department, obtaining the view of the judicial department, and with the approval of highest government authority, the impugned acts are only in the identifiable group and section of the candidate who had appeared in the main examination. My humble submission before your lordship is this: all these things has been stated, my lord. Is the, my lord, stigmatic view against the petitioner, my lord. And this is the foundation. They have admitted, they themselves admit, this is the foundational fact. To, my lord, discharging me from my service, my lord. If that is, my lord, foundation, my lord, then, my lord, I should get an opportunity for, my lord, submit my huh? Yes, sir. Yes, ma'am. All these things has been, my lord, Dhingra case, my lord, and other, all these things has been stated, my lord. And on the basis of that, my lord, they have, my lord, segregated the tainted person and non-tainted person of the selection process, my lord. Only on the basis of that police report, my lord. If that is so, my lord, then, my lord, we should get an opportunity, my lord. If the whole batch has been, my lord, they have been, that all selection list has been set aside, then that is different aspect of it. Then you have segregated, my lord, that Assamese than patan, English said, my lord, gain from safe, my lord. If that is so, my lord, then I should get an opportunity, my lord. And, my lord, most important, this police report is not proof, my lord. Till date, my lord. Trial pending. Trial is going on, my lord. And your lordship knows very well that police report is not a conclusive evidence, my lord. On the basis of it. Or more particularly that I have categorically stated, my lord, that we never admitted before the, my lord, police investigating officer that we have given money. And that statement is not available in the special code, my lord. All these points, my lord. And my lord, group of section who have APN main exam, the identity group are only those candidates where duplicate answers are submitting, answership were recovered from confidential exam, the identifiable group alone were discharged from the service and again from charge sheet has been filed. Meaning thereby, my lord, it is the investigating officer, my lord, who has decided who will be terminated from service or not terminated from service, my lord. This is the foundation. And my lord, you will see that Punjab case, my lord. Inderpreet Singh Kalu, my lord, judicial affair investigated the matter, my lord. They are police officer, my lord. I should not submit, my lord, what happened subsequently if trial is going on. What will be happen, my lord? Next day, my lord. One case is NDPS case, my lord. I crossing witness. The expert said that I do not know whether this substance is NDPS substance or drug and cosmetic substance. Because there are 4 ingredients in respect of opium, my lord. Only 1 ingredient has been, my lord, investigated. Other way examined. Other 3 were not examined. I saw you. Section and would be appear. The identical group alone were discharged from service against whom charge sheet has been filed. Have you also got 742
Yes.
page number? Yes, my lord. There are 52 writ petitioner, 8 candidates who are not before this court. Allegation are with the criminal conspiracy resulting tampering with the examination process for the petitioner. Investigation have revealed that petitioner has indulged unfair mean or getting selected by paying bribe on extraneous conditioner on account of their cause and method which respond to the deprived satisfaction the selection process to which the petitioner came to be selected. Eventually, they are tainted by fraud, irregularity, and the selection appointment petitioner being found threshold itself cannot be said thus the election bona fide and discharging the petitioner from service and was not solemn duty state take into action for maintaining the sanctity of the government. Can it be said that it was not open to the state government to act disturbing revelation emanating from service police investigation with regard to grave irregularity being discovered involving the petitioner during the selection process, which illegally occurred well before entered the service? To reiterate and discharge the petitioner from service was not on account of alleged misconduct after appointment, but on discovery of fraud on the appointment of her entry service. Again, I am relying on Ratnesh Kumar Chaudhary. I am submitting one thing. I saw your lordship in respect of Abhisheka Barua.
Abhisheka Barua.
Yes, my lord. She has, my lord, also getting the job by obtaining fraud, my lord. She herself has been admitted before the, my lord, when statement has been recorded, my lord. How can he get the, and in respect of, my lord, I am not, in respect of her case, my lord, the appointing authority has started departmental proceeding. So my submission, that is the correct procedure as per my submission, my lord. If that is has been given to him, my lord, her, my lord, or Sanjana Fukan, same, my lord, procedure should be followed to me. Otherwise, violation of Article 14 and 16 of the Constitution of India. Illegal to return the discharge the petition service on the alleged misconduct. There is a clear dividing line between challenge made in order to discharge on ground of misconduct during post-recruitment period and challenge made in order to discharge ground of illegality relatable pre-recruitment period, whereas former would invariably invite compliance audio term part-time rule of natural justice and or compliance protection granted Article 311 of the Constitution. The latter can fall within the category exception of rule, ODL particularly there are, so far as petitioner are concerned, examination process and the selection initiated. Going back to Purushottam Lal Dhingra and Samsung said it was only when the termination seemed to be found that manifest misconduct, it will be punishment will go to violator Article 300 inquiry. However, as observed above, the argument misconduct of the being the foundation are wholly misplaced, misconceived, inasmuch to discharge the business service are not founded phenomena of misconduct as is understood service jurisprudence. My lord, what my lord, Honorable Single Judge has said, my lord, that after the appointing them, my lord, in service, my lord, there is no misconduct took place. It was before misconduct. So my sorry, my lord, honorable my lord.
Before joining, there was a.
Yes, my
fraud,
lord.
huh?
And to that answer, the Ratnesh Kumar Chaudhary, my lord. And I am going to the Purushottam Lal Dhingra case, my lord. They are nowhere stated that due to this, my lord, post recruitment, this rule will be followed, and pre-recruitment, that rule will be followed. In Samshed Singh also, that is not available, my lord. In my written argument, I shall give all these things, my lord. And if I get opportunity last, my lord, then I also distinguish that judgment.
Definitely, you'll
If
get a-
someone is not distinguished, my lord, senior lawyer is not distinguished, my lord, then I shall distinguish.
Definitely.
Then, my lord, para 48. Itu mana ko kan dito sa 48 dala. Now you look see come to para 49, page 744. Have you also got it?
Yes.
744. In Inderpreet Singh Kahlon and Joginder Pal, the Supreme Court had dealt with two category candidates who had been selected to the executive post through examination conducted by Punjab Public Service Commission. They were categorized as tainted and non-tainted candidates. Taking cue from Inderpreet Singh Kahlon, this could hold that if services appointed are to be terminated after having put few years on service, what would imperative are that sufficient material have been collected on the basis of a thorough investigation in fair and transparent manner, that the illegalities committed have gone the root of the matter, vitiating the selection and appointment, and that the appointment must be found to be a part of fraudulent purpose, or the system must be found to be corrupt. Applying the above principle, they are not denying the fact. Again, each sufficient material has been collected through a process through investigation, and the material so collected described gave irregular involvement of the petitioner. I pause here. We have, my lord, objected all these things. Every allegation we have, my lord, objected, my lord. If something has been said, my lord, by the other side, I shall give reply. Otherwise, my lord, it will be angry process. My lord. The gravity of illegality found to have been committed where such have gone to the root of the matter, they are vitiating their selection. In Joginder Pal, in respect of the petitioner, therein who were found to be tainted candidates were facing criminal trial. The Supreme Court held fate of such candidates do not pose much a challenge. It was found that they have indulged unfair means and selected by paying bribe because of extraneous reason, certainly not an other merit. This is precisely case of the hearing that has revealed the police report. Although the petitioner was discharged from service by taking recourse to the provision of governing services relating to discharge petitioners, what stand of the predominantly is that discharge from the service was viewed a commission of illegality in the selection process involved with indefeasible group which included the petitioner. Therefore, argument made on by the petitioner questioning applicability relevant services also the provision of 300 constitution is not required to be gone. More so, the foundational facts reveal the police will duly consideration. My lord, my humble submission, this is incorrect view, my lord, because police report there is a stigmatic view, my lord. Everything is there, my lord. Even it is assuming, admitting all these things, my lord, that this is available in the police report, my lord. And if it is the foundational facts, my lord, then I should get an opportunity to give reply, my lord, and cross-examining the persons also, my lord, to that extent. Commission of Inquiry Act, other case, Section 8, my lord. I am not on that, my lord. I was not get, my lord, opportunity of these things, my lord. I want to show, my lord, that judgment, my lord. Inderpreet Singh Kahlon, my lord. 2006, 11 SSC 356.
Same facts. ইন্টারফেস করে পঠাই দিছে কমিটি বানাইছে
অলপ বুজি গ'লে পঢ়িম। অলপ মনত পৰি আছে এতিয়া লাহে লাহে। 2006-11 SSC 356. Same identical fact like us, my lord. It was sent to the my lord,
Remanded to the High Court back.
remanded to the High Court bill,
Interfere with
interfering the discharge order. I am reading that 2006-11 SSC 356. Indobit Singh, Kehlon, my lord, and others. Your lordship kindly confirm the page 117, 18.
Paragraph 100.
Sorry, paragraph 118, my lord. I've given book list also. দুটা আছে নেকি নাই আছে না দেন না তাকে দেবী যাব এটা কপি অলয় মানে কিবা কৈছে আছে বুলি কৈছে 2016-11 SSC 2006-11 SSC 356.
Paragraph.
Paragraph mile 118 mile. 41 onwards mile. This is identical face like us, my lord. May I read, my lord?
Yes.
Undoubtedly, in the selection process, there have been manipulation and irregularity at the behest of R.S. Sidhu, the then chairman, service on carefully scrutiny, facts and circumstances of the considered opinion. The High Court ought to have been made a serious endeavor to segregate the tainted from the non-tainted candidate. Though the task was certainly difficult by no stretch of imagination, it was impossible task. The peculiar facts of this case, which need to be highlighted, are that some candidates have worked for about 3 years and their service were terminated only on the basis of criminal investigation was at the initial stage. When we are terminated, we are completed 2 and some year month, my lord. The termination of the service as consequence, cancellation would not only prejudice to their interest seriously, but to future career. It may be pertinent to mention that during the period, there has been no allegation regarding the integrity and efficiency of this officer. In respect of us, my lord, no complaint, my lord. The fact of the case revealed that material supply committee having regard to the majority of the offense name in the FIR belong 2001 batch. The respondent not only cancelled the entire selection, but on the basis of cancellation selection 2001 batch and the process 1999-2002 selection was cancelled. Same, my lord, in respect of us also, my lord. This Nabokanda Pati kuntu batcha asilo. Anyway, my lord. It's also even that the selection 1998, not the subject matter had been made when selection of this year well officiated. The High Court Committee, without being sufficient and adequate material record, recommended cancellation of selection, both executive, judicial officer, and full bench, either in accepting the recommendation, terminating the service of all officers. As cause scrutiny of the affairs had clearly revealed that judicial officers did not get fair treatment of the High Court. They were not given copies of the report, other material on which reliance was placed, and they virtually had no chance of making effective representation before the committee, and had other forum where they could ventilate their grievances and present point of view. When the basis of termination serious allegation of corruption, then it is imperative the principle of necessity fully complied. Same identical fact, my lord. Here also the basis of police report. In my case also, my lord, police report. Only on that, my lord. And paragraph 126, my lord. Page 415. While following the ratio of the said case in fact and circumstance, we deem it appropriate set aside order of the respondent in en masse selection, direct the respondent to examine the case separately on its merit and submit a report to the court. Termination of the set aside, same. And directed to segregate, my lord. Not tainted and non-tainted candidate, my lord. And your lordship kindly allow me Ratnesh Kumar Chaudhary to. Ascend that, sir. By him. Attack of it. Next, Ratnesh Kumar Chaudhary. 2015-15 SSC 151. We also relied in the single bench mile para 18 of the judgment as categorically stated. Para 11, no? Para 11 mile. And your lordship kindly come to the
Ratnesh Kumar
Chaudhary.
Chaudhary,
2015-15 SSC 151.
2015, 15 SCC,
151.
yes.
Yes, madam. First, you will kindly go to the para 1, my lord. That there is a post, my lord. One is, my lord, sex therapist, my lord, physiotherapy.
We have it.
Yes, my lord. Physiotherapist and sex therapist, my lord, advertise. The selection committee institute appointment to the post of sex therapist. The screening on the observe the post of physiotherapist and sex therapy are similar in nature. Hence, the post of sex therapy may be considered from the application received from the post of physiotherapist. Accordingly, my lord, para 3, my lord. That is important, my lord. Everything is there, my lord. When the applicant was coming to the post of sex therapist,
We'll have to rise for the
Yes, ma'am.
other bench, the single bench of my esteemed sister.
yes, madam.
We'll continue tomorrow.
Yes, madam. I will take only at 2 or 10:30, madam.
Will be second half.
Second half,
Be
yes,
better.
madam. I will take 15 to 20 minutes. Complete. And also I submit a written, my lord, initial written argument.
So all sides that you represented. Give the names of the parties. Mr. Kohli is there. Mr. Chaudhary is there from video conferencing. The submissions of Mr. NNB Chaudhary, Learned Counsel for the appellant in WA 47 of 2021 remains inconclusive. List again on. Preferably at 2.
Yes, sir.
Grateful. Grateful, Lordship. Leadership. Grateful.